Welcome, ladies and gentlemen, to the Saturday HOA Brunch, presented by Angius&Terry, LLP. Please sit back, relax, and join Brad Epstein and Jonathan Broderick for an hour of entertaining information about HOAs and HOA law.
It's Saturday morning in the city of trees. It's the Saturday HOA Brunch. We're back. The trees are still green. The clouds are starting to clear. The sun is starting to shine down over the Sacramento Valley. Frank Jolly's in the back on the sticks. Bianna Barbu in studio.
Good morning, everyone.
Attorney Brad Epstein.
Good morning, everybody. Looks balmy out, doesn't it, Jonathan?
It could get balmy. It's been a long week. It's been a long week for everyone in our industry. And I think that you want to begin with possibly paying some respects to a dear friend that passed away.
Our dear friend Dan Kocal. Dan Kocal was a leader in the community association industry. We're going to be somewhat subdued today. He passed away last week. And our thoughts and prayers go out to his family and his fellow employees, all the folks at Kocal Division Management Trust, and everyone at I think there's 8 or 9 offices of the Management Trust. He was a founder of Kocal Management, one of the best management companies, period.
Great people work there.
Yeah, and the company, of course, is going to still go on. They're still strong. The show goes on. We just hope all the best to Dan Kokal's friends, family, and all his company members. It was an unexpected passing away, and we're very, very sad. We will sincerely, truly miss Dan Kocal. He was a friend of mine and worked with him for over 20 years.
Nice gentleman, leader in the industry. So we do pay our respects to all of the Kocal family and the employees of the Management Trust. So we're here, the Saturday HOA Brunch, community associations, homeowners associations. We are going to educate and enlighten today. I'm excited.
Yeah, absolutely excited. What we're going to have today is another episode of our quiz, the
Battle of the Board Members.
The Battle of Board Members. We have 2 great board members today. I am so happy that they are going to be on our show as contestants. We have Mickey, and he is from Foster City. Jonathan and Vianna, do you know how long Mickey has been on board of directors?
Is it longer than
20 years?
Vianna and I have walked the earth.
Longer than I've been alive.
yeah. Mickey has been on the board of directors for, check this out, everybody.
Give it to us.
34 years. 34 years. Mickey,
years.
A great guy. He is a real funny guy, and of course he has a wealth of knowledge, very smart, so he's going to be playing in our Battle of the Board Members on our quiz. Also,
is that an Iron Man award that,
definitely.
that should be given out in the industry?
Definitely.
He's probably has more board meetings participated than Cal Ripken games played, if 34 years.
Well put, Jonathan.
I would love to hear his stories, the things he's seen, I'm sure.
Oh, yeah, absolutely. Also, we're going to have Claire. Claire has been on board of directors for 7 years, and Claire is from Cameron Park. So we have Foster City versus Cameron Park, and Claire is just anxious to go.
Claire, that's a special place to live, Cameron Park?
Cameron Park, a special place to live.
A special place to live.
Great place. Yeah,
great
we have
community.
a lot of listeners from up there, and our listeners now are listening to us from all over, even as far away as Foster City, by virtue of
iHeartRadio.
I think as far away as Romania, I'd say.
Oh, wow.
You got some, family out there, Bianna?
Yep.
The rambunctious Romanian.
Awesome. Okay, so if you want to call in, 888-923-1380, 888-923-1380. You can ask us questions regarding your community association, or if there's a specific area where you need a little bit more information, because as you know, we've discussed HOA banking, we've discussed reserve studies, we've discussed some of the industry organizations, CACM, Community Associations Institute, we've talked about elections, we've talked about association security, we've talked about new bills that affect homeowners associations, community associations. We've even had a lobbyist who, on behalf of community associations, is down on the Capitol steps, Skip Dom, every week. Conflict of interest, internal dispute resolutions, rules. So what are we going to talk about today, Bianna?
Well, today we'll talk about the most exciting topic in homeowner association issues, contracts.
Super important, right, Vianna?
Right. It's maybe not as exciting, but this can get you into trouble if you don't do it right.
What kind of contracts? I mean, when you're talking about contracts, we're strictly discussing contracts that like boards of directors would make decisions on behalf of their community associations?
Well, boards of directors, but also there are some types of contracts that the homeowners would also have an input in. So we're talking about construction contracts when something needs to be rebuilt or repaired, or
Reconstruction,
maybe
Roofing.
hiring vendors for landscaping or other purposes. So we're talking about pitfalls to avoid when entering into a contract, elements to look for and make sure that they sound right to you, and which provisions are key in protecting associations.
So I think we have some great bullet points on the definite do's and don'ts that associations should think about. Right, Bianna and Brad, this is kind of your wheelhouse. You get the contracts from the associations, you review them. What are some of the do's and don'ts that you two feel are
think,
substantial?
I think one of the top I think no attorney would ever argue with this one, is use a written contract. Do not enter into oral contracts.
No
Not
handshakes?
a good idea. Yeah, there are some contracts that if they cannot be performed within a year, they violate the statute of frauds, and they have to be in writing. So you cannot have oral contracts that are to be performed in over a year. So make sure you use written contracts so everybody sees the terms, understands the terms, and you have a
pen, not pencil, preferably.
Sure.
Well, yeah, we have erasable pens, but I wouldn't suggest using those on our
famous
on your
erasable
written
pens.
contracts.
Every attorney should have an erasable pen. And always try and use the association's contract form, especially when it comes to those contractor agreements. But yeah, we're talking about for contractors, for roofers, and landscape architects, to name just a few.
And
Okay.
you always require insurance and proof of insurance for your contractors. Do not hire contractors that do not have insurance or can't offer you proof of insurance.
Yeah, so we'll give a shout out. We have a community association insurance sponsor, Russo Insurance Agency.
Russo Insurance Agency.
Yeah,
Rick
okay.
Russo, great guy.
Next bullet point, do's and don'ts.
Always specify the independent contractor status on the contractor.
You mean
What
you
does
want
that
somebody
mean?
that's in good standing with the California State Contractors License Board? You don't want someone that's been suspended or what? Go ahead. Come on, elaborate.
Well, yeah. How can you check that, Jonathan? Is someone
You could probably just log on
right
to the state website
Internet.
and review their license number and see
Sure.
what their status is.
Sure. And what you want to do is you want to make sure that on the contract it provides that the contractor is an independent contractor, not an employee of the association. What does that matter? Well, it matters a lot because of liability. You want to make sure that that contractor is independent from the association. Primarily today we're going to be talking about contractor contracts, because that's the most contracts that associations. Jonathan, you have something?
Yeah. Okay. So then we have two more things, and then we're going to go to Miss Becky Davis, who's called in. She has decided to remain anonymous on the location, so possibly she's from Romania. We have two more quick points we're going to get to, and then you have a question regarding community associations, right, Miss Davis?
Yes, I do.
Okay, sit tight for two more points we want to make in this first section in regards to contracts, and then we're going to go ahead and
Sure.
get to your question.
Yeah.
No problem. Thank you so much.
The next important point that you should always look for in your contract is make sure you review the scope of work. Make sure it is clear and you understand what the contractor will be doing.
Sure. Let's go ahead and hear the question.
Yeah, go ahead before we go to break. What's your question, Miss Davis?
Yes, I belong to a small homeowners association here in the Sacramento area, and Mr. Epstein has been our attorney on record for a number of years.
Excellent.
And speaking of contract, every homeowner who purchases a home before they purchase the home agrees to the CC&R provisions.
Okay.
We currently have a resident who's lived here for 5 years.
Yes.
And he has a disabled placard.
So this is in regards to ADA, Miss Davis?
Should she hang on?
Yes.
Yeah, hang on. When we get through the
We're gonna go
break,
to break.
we're going to come
Can you
back,
hang on?
and we'd love for you to finish this up because I think this is going to be a great talking point for our second quarter to kick off. How's that, Miss Davis? Just sit tight.
Sure, no problem.
We'll be back.
Absolutely.
20 years of credit counseling and debt management services. More than 36,000 program members freed from credit card debt. Nearly $100 million saved in high interest and finance charges. It's Trinity's 20th anniversary, and these are just a few of the milestones we're celebrating as we begin our third decade of helping people become debt-free for keeps. Did you know that members who complete our program save on average more than $20,000 in interest?
My name is Mike. From the very first phone call, Trinity brought us relief by stopping all the late fees and collections calls, greatly reducing our interest and consolidating our bills into one easy-to-manage monthly payment. Now we're on track to save nearly $17,000 in finance charges. Happy 20th anniversary, Trinity. Thanks for helping so many save so much.
And Trinity can help you, too. Call 1-800-990-6976. That's 1-800-990-6976. 1-800-990-6976.
If your community association has a good relationship with their current management company, you can stop listening. However, if you are struggling with your current service provider, we'd love to talk with you to see if Omni Community Management would be a good fit. Transparency, education, communication, and trust are just 4 of the qualities that set Omni apart. This is Rolf Crocker, CEO of Omni. Call us at 916-965-8964. That's 916-965-8964. Online at omni-mgt.com. That's omni-mgt.com. Omni Community Management, your friend in the community association management industry for over 20 years.
Have you ever heard of the saying, a person's home is their castle? Of course you have. But sometimes a construction defect can turn your castle into a catastrophe. If this happens to you, you need proper and professional representation. You need Angius&Terry, LLP. For over 30 years, the attorneys at Angius&Terry have been effectively serving homeowners and community associations, recovering more than $500 million on behalf of their clients. Angius&Terry strives to ensure that your construction defect claims are prosecuted in an aggressive and cost-effective manner. Angius&Terry will also continue to work with homeowners and community associations after the construction defect claims are concluded to make sure that the money received from builders is spent wisely and that your interests are protected during the repair process. Don't let a construction defect turn your castle into a catastrophe. Call Angius&Terry LLP today at 916-567-1400. That's 916-567-1400. Online at angius-terry.com. Angius&Terry LLP.
News, opinion, insight. AM 1380. The Answer.
You're listening to the Saturday HOA Brunch presented by Angius&Terry LLP. And now your hosts Brad Epstein and Jonathan Broderick on AM 1380. The Answer.
Hey, we're back. Yeah, we're back. The second quarter of the Saturday HOA Brunch. And we are delighted to have a call from Miss Becky Davis. Now, your question, Miss Davis, there was a gentleman that's lived in an association for approximately 5 years now, and he has, he's apparently handicapped. And this is in regards, this is an ADA question, and I think you're going to serve this one up for Mr. Epstein.
Yes. Okay, so when a person purchases a home here, they do get a copy of the CC&Rs that they agree that they will keep their vehicles garaged. We have both single car and double car garages in our community. This particular gentleman and his wife have 2 cars, and for 5 years, the wife parked outside of the association, and the husband parked his car in the garage. But recently, he is, because he has an ADA placard on his car, has asked the board if he could permanently park his car in guest parking and let his wife use the garage for her vehicle. And then he also cited a couple of vehicle codes, and he cited an attorney who said that federal law trumps state law and local and HOA requirements. So the board has currently said yes, and of course there were a number of homeowners who said, no, we want all cars garaged, please. Why is he suddenly allowed to park his vehicle out in the common area when he has a garage to park his car in? So we kind of wanted to get your input on this. Oh, and we are private property. We have no public facilities, no pool or clubhouse or anything like that.
What a great question. Yeah, it really gives a good factual basis for our answer.
She really drew that up nice. I had a visual going.
Yes. And so in an association that does not have any public accommodation, especially one that's gated, then the ADA, the Americans with Disabilities Act, does not apply. That doesn't apply. However, we have what's called the Fair Housing Law. We have the Fair Housing Law both federal and state, and this provides that associations must give reasonable accommodations to the rules for those who are disabled persons. And it's a give and take process, especially when it comes to parking. Your association, no doubt, has great taste in legal counsel, and your legal counsel is working with your board of directors on this, and so it's going to be some give and take, and hopefully this one's going to come out right for all the homeowners. I understand completely the individual owners coming home and saying, well, wait a minute, we got to put our cars in our garages. How come this one isn't? So it's going to take some give and take on the overlay that associations must make these reasonable accommodations. Some bend the rules with persons with disabled. Becky, thank you for your call. Hopefully this is going to come out right and something that's fair to all owners.
Okay, thank you very much.
Thank you, Becky.
Bye-bye.
Thanks for the call, Ms. Davis. Okay, so real quick, Bianna, you had 2 more points that are important in the do's and don'ts that associations should think about in regards to contracts. The last 2, Bianna?
Well, I did mention that reviewing the scope of work right before the break, so I just want to make sure that everybody remembers that that's a really important part of the contract. Always review the scope of work, and always confirm that your contractor's license is current. That's important. So make sure that you're looking at the dates and make sure it's current. And the last point would be to never ignore contract deadlines. That's an easy way to breach a contract. So what I mean by contract deadlines is deadlines to make payments, deadlines to notify termination of a contract, any kind of deadline. You don't want to be the party that's in breach of that contract.
Excellent. Okay, I want to check in with another friend that's called the show, and he is waiting to play Battle of the Board Members. Mickey.
Yes.
How are you doing?
I'm doing well, thank you.
Yeah, for a Saturday morning, you got a cup of coffee, you're getting ready, you're listening a little bit in regards to contracts, and you're going to participate today in Battle of the Board Members. Are you excited?
I'm looking forward to it.
Yeah, where are you calling from, Mickey?
Foster City, California.
Foster City. So I don't know if you heard at the beginning of the show, Vianna and I were kind of in awe because you have volunteered to serve your community association for over 34 years. Is that correct?
That's true.
Wow.
Hey, and also now, Mickey, you are a member of another community association organization. Is it like a organization just for presidents or a board of directors? Do I have that right?
Oh, well, tell us about that.
Board of directors in Foster City, it's United Homeowners Association. It's united all the homeowners associations of Foster City and their board members.
How many members, Mickey?
There's 32 members of our association, and there's about 36 associations in Foster City.
What's the mission of this organization?
Just to work with the city to the benefit of homeowners associations so that they share equally in what the city enjoys as far as landscape and water restrictions,
aesthetics for the community, things of that nature.
Exactly.
Now, I'm curious, qualifications for applicants of the United, what was the name of the organization again?
United Homeowners Association.
United Homeowners Association. What qualifies, besides being a board member, are there any timetables for experience or positions on boards of directors?
No, it's any board member that is a member of an active member of an association currently serving.
Excellent. Mickey, we are glad that you have joined us today. We are going to jump in. We're honored. 34 years, board member, volunteer community board member. Mickey, that's just great. So we're going to continue on with our conversation in regards to contracts
for associations. So a couple of things that we want to underline in what Vianna was talking about was the scope of work. So when an association goes out to bid for contracts, what do they need to know in particular is they need to know what the scope of work is. apples to apples, oranges to oranges, right?
Yeah.
We need to have that, right, Jonathan? You have experience with that in your construction background?
A lot of times what would happen is in community associations, every 7 to 10 years, they're gonna repaint the association. A lot of times you'll call one of the paint companies, Kelly Moore, Dunn Edwards, Vista, Sherwin-Williams, Behr, Glidden. I could go on and on and on. And they also have someone that professionally will come out, set up a job walk. He'll bring 3 or 4 qualified vendors. He'll write a spec for the project on which products you should use on certain substrates.
With a construction manager?
No, this would be a representative from one of the painting manufacturers for writing a spec for a community repaint.
I gotcha. Right.
A construction manager, now you'd bring him in on a large scale, for example, dry rot replacement, reconstruction project. Maybe you're going to be ripping out 50 balconies and you want to make sure everybody's bidding apples to apples. They're using the same types of materials, whether it's for the deck coating or the grade of lumber that's being used. These types of things, what a construction manager can do is he can actually set up a schedule of values, which will help with completion and payment schedule, keep the project moving forward, communicate with all the parties that are involved, whether it's getting the members informed on events that are going to be taking place throughout the community, scheduling, what phase, you could go on, and we've only got like 30 minutes left, so if you want more information, I would suggest showing up at one of the industry events, because there's plenty of vendors there that would love to let you know what you can benefit from by using a professional.
Right, and some contracts that associations have, as Viana said, must be actually approved by the individual owners by virtue, this is a bylaw or CC&R provision. The Davis-Sterling Act doesn't provide for any limitations, doesn't restrict board of directors on what contracts they can enter into. However, community association CC&Rs and bylaws, they do have provisions in them sometimes that limit what contracts boards can enter into, such as some bylaws provide association board members must get the owner's approval for long-term contracts over a year and whatnot, with some exceptions. Other things you want to be aware of. Be aware of these. Again, the scope of work, that needs to be tight. It can't be vague or inadequate. The deadlines for payment. Remember, your board of directors only gets together every 30 days or even longer. And also a trick is the automatic renewal provision for service contracts. Sometimes it's automatically renewing unless you go ahead and you provide for a termination within, say, 60 or 30 days before the end of the contract. Limitation of liability clauses. This is something you want to look out for, everybody. This is huge. This is provisions in contracts for architects, landscape architects, engineers in particular. They provide for a limitation of that contractors being liable. Sometimes they'll have a certain dollar amount or the amount of the contract. Be very careful of these, very careful. Indemnification clauses. Viana, you want to tell us a little bit about indemnification clauses?
Yeah, and so indemnification clauses are those where you're asking that the contractor indemnify the association in the event that something goes wrong with the project. So you want to make sure that the indemnification clause goes in your favor. So it's basically protecting the association and not protecting the contractor.
Right. So here's your contract. You have a roofer. Contract with an association. The roofer is out on the roof. What's he doing? He's re-roofing. You have a homeowner down below looking up saying, "Oh, how's it going?" The roofer says, "Hey, howdy down there." The roofer drops a hammer on the head of the homeowner, and the homeowner gets injured. The homeowner is injured. Who's the homeowner going to sue? They're going to go ahead and sue not only the contractor, they're going to sue the association. So you need a provision in the contract that provides that for any third-party claims by someone other than the contractor that are against the association, that the contractor goes ahead and covers the association's liability. That is the indemnification clause. Also, you want to have, it's called defend, indemnify, and hold harmless. Defend, indemnify, and hold harmless. Also,
say
the provision,
that 3 times
you
fast.
got that right. And the association will then be protected against not only attorney's fees, the judgment. Also, they won't be liable to the contractor themselves. Indemnification clause is very important.
Okay. It's time for us to head to another commercial break. Mickey's on the line. Our other competitor will probably be joining us during the break. We've got a couple of more things to brush you up on in regards to contracts. So drive safely if you're on the roads, and we'll be back with you shortly.
I love coming to Mathnasium.
At Mathnasium Learning Centers, we make math make sense to kids. Your child will leap ahead, whether starting out way behind or already ahead. It's how we've grown to more than 500 franchise locations. Now enrolling for summer and year-round. Call now for a free parent pack. 844-799-4999. 844-799-4999. Learn what Mathnasium can do for your child. 844-799-4999.
I'm Eric Kipple, 10-year veteran of the NFL.
I'm Captain Mark McNeil, 16-year veteran of the Army National Guard. Whether on the playing field or the battlefield, you must be both physically and mentally fit.
If you're injured, you owe it to yourself and your teammates to get back to peak performance. It doesn't matter if you've got a broken bone, depression, a traumatic brain injury, PTSD, or another psychological wound.
Getting help shows strength, not weakness.
To find out more, go to realwarriors.net or call 866-966-1020.
AM 1380. The Answer.
Hi, this is Rick Russo, owner of Russo Insurance Agency and Financial Services. We proudly serve Granite Bay, Roseville, Rockland, Sacramento, Lake Tahoe, and the surrounding areas. At Russo Insurance Agency, we like to say, get to know us before you need us. Our insurance agency is built on relationships and trust. If you want to be certain that your most valuable assets are insured correctly, allow us to give you more than just a 15-minute quote. For all your commercial, home, auto, and life insurance needs, call us today at 916-791-1901. That's 916-791-1901 or online at rickrussoinsurance.com. That's rickrussoinsurance.com. Thank you.
Having trouble understanding your community association's reserve study? Does your HOA's reserve study seem to be written in a strange language? Hi, I'm Robert Browning, owner of the Browning Reserve Group. At the Browning Reserve Group, we have been providing easy-to-understand reserve studies since 1999. We actually listen to our communities and help them plan for the future. Find us online at browningrg.com. That's browningrg.com or toll free at 877-708-0600. That's 877-708-0600. Clarity from complexity, the Browning Reserve Group.
You're listening to the Saturday HOA Brunch presented by Angius&Terry, LLP. And now your hosts, Brad Epstein and Jonathan Broderick on AM 1380, The Answer.
We're back, the Saturday HOA Brunch, AM 1380, or you can listen on iHeartRadio every Saturday morning from 9 a.m. to 10 a.m. And we're talking about contracts today.
We've talked about arbitration before, and your contract can have an arbitration provision. So what's arbitration?
That's like baseball players. They say, no, I'm worth $11 million.
Yeah.
I'm not taking the minimum this year.
Yeah, in contracts. So what that provides is it's a clause that provides that any kind of a dispute with respect to the contract, that's going to be resolved not by going to court, but it's going to be going with respect to someone that both parties just pay for. Some people call him a rent-a-judge, right? It's an arbitrator. He's going to go ahead and he's going to render a decision. It could be binding or non-binding on the parties. What this could provide for, it's something you want to think about. It used to be, oh boy, we don't want to have a binding arbitration provision in a contract if we're in an association. We want to have a jury, a judge, make our decision in court where you have a right of appeal, right? You have a right of appeal with a court trial. You have jury or judge. Well, in this case, you're not going to have that. It's going to be quick. It's going to be cheap. And it's going to be something that you want to consider in your contract. Depending upon the contract, it could save you a lot of money if you have a dispute. So something to think about, Viana.
Yeah, so we've been talking about construction contracts, and there's a lengthy checkoff list that associations should think about. So let's talk about a couple other issues that when you're signing or entering into a construction contract, you should think about. So we mentioned before contractual provisions that require the HOA to indemnify the contractor. Make sure that if that's what the contract says, you strike that out or at least negotiate for it to be revised. So another issue to consider is requiring indemnity provisions in favor of the HOA, except, you might want to input this language, except when the damage is due to the sole negligence of the homeowners association, because in that instance, you obviously would want the association to take responsibility for something that it exclusively was responsible for. Another thing to consider is making sure that the warranty provisions have a strong language and are clear. For example, what I mean by warranty provisions is the work is basically guaranteed, and you'd get either a money refund if the work is subpar, or the product or the construction breaks down, or that the construction company agrees to replace the part or the actual structure in the event that the whole structure is damaged, and make sure that you also obtain consequential damages that result as a result of any kind of breach or failure on behalf of the construction company. So consequential damages would be not necessarily the amount that it would take to repair the structure, but maybe the time that you'd had to, or the time you had to have people park somewhere else and you had to pay for that, or something like that. So any
relocation,
kind of consequential,
possibly if there was something where like it was
a homeowner was
you
had
were
to be
removing
relocated.
mold and it took longer than the expected time, and the contractor had to
Right.
displace the homeowner. So that those are the areas that you're talking to in regards to warranty provisions, Bianna?
Right, and then you want to make sure that certain insurance requirements are met in your contract. So we'll talk a little bit about insurance coming up, but we really want to make sure that the contractors you're hiring are insured, and that they have certain policy limits that they depend on the scope of work and the size of the project and what they're doing. But you want to make sure that you're covered in case of any liability, and that the contractors themselves actually provide the insurance for that, the coverage for that. So other additional items to be aware of in construction contracts are, again, limitations of liability, arbitration clauses and mediation provisions. You know, they can be very beneficial, so you want to make sure you read those carefully and see if you have a right to arbitration, or if you have the right to maybe mediation, or if you want to take that up in court and go to a jury. So,
and most importantly, make sure the scope of work is clear. Right?
Yeah, and how would you do that, Jonathan? Just in case, I mean, construction contracts, they're confusing to a lot of people. They don't know what terms are being used, what some of this stuff in there means. So what would you do?
Well, you know, I always enjoyed getting together for lunch. So, you know, if there's an architect or a construction manager already involved in the project, it doesn't hurt. Call up the community manager. Get the community manager, the architect or the construction manager, the contractor, sit them all down, review the language, and make sure everything's clear.
Yeah,
communication is key.
Yeah, communication is key, and then get someone else, maybe somebody that is in the profession, to review the contract with you or the scope of work, and make sure that your understanding and their understanding are the same. Now, if you negotiate successfully, there's a couple of things that you could probably get away with that would be in the benefit of an association.
Okay.
So you might want to strike out any payment requirements that require payment that's due within 30 days or less. Payment deadlines that are 30 days or less are very, very hard to meet. And as Brad mentioned earlier, boards don't meet that often. They usually meet once a month. So if your payment is required within 30 days or less, then you might miss that deadline. So you want to strike out payment requirements that require short deadlines.
2 more strikeouts because it's baseball season. They are?
Yeah. Wait. We have Claire on the line.
Hey, Claire.
Hello.
How are you doing?
I'm doing just fine, and yourself?
I'm doing great. Where are you calling from, Claire?
I'm calling from my home.
Okay.
Cameron Park.
Cameron Park, a special place to live?
It is very nice here, very special.
Excellent.
Thank you for joining us, Claire. Hang on the line and listen to more of this law before we get to
Battle of the Board Members. Claire, are you ready?
I'm ready.
Okay. So hang on the line. We're going to go ahead and go through some more law before we come to the quiz. So next is you want to strike out any attempt to shorten the statute of limitations, right? The statute of limitations, that is the deadline for plaintiffs to file their lawsuit. There's deadlines for plaintiffs to file lawsuits in any kind of court case. And for instance, construction defect cases, that is associations or homeowners suing for defects in the construction of their home, in addition to some shorter ones, there's a big 10-year statute of limitations. So sometimes you'll have that contractor sneak that in and saying, you must sue us within a particular deadline, 1 or 2 or 3 years. And nope, get rid of that. No statute of limitations shortening. And
you also want to strike out any provision that deems that the HOA to have waived an objection if the action is not taken by a certain time period. So what I'm trying to say is that if there's a provision that says if you have not objected to, for example, the performance of our work within 2 months, then you have waived that and you can never complain about our work product ever again. So any kind of provision that would shorten your objection time should be struck out.
Excellent. Okay, let's talk about insurance, you guys. So this is super important. right?
Absolutely.
If insurance isn't there, then you're going to have trouble in any kind of a lawsuit on behalf of the association against that other party that you contracted with. You have troubles with a contract or later on construction defects, you want to make sure that you have insurance in place that is covering that defendant. Nowadays, insurance really drives lawsuits. It is very rare for a party to sue another party in a commercial setting, such as an association contract, with a contractor that isn't resolved through insurance. The insurance for the contractor provides for not only the payment to the association of any potential judgment, it also provides for a defense of that contractor by an attorney. So oftentimes it's sort of counterintuitive. You sue someone, an association sues a contractor, and you actually want that contractor to have an attorney. That gives you the ability to make it a more of a professional resolution. And typically, if it is a contractor, that insurance defense counsel, by virtue of the insurance policy, will be paid for by the insurance company. So it brings it up to a level of professionalism in order to get it resolved. There are certain limits. You really don't want to have an insurance policy on behalf of that defendant contractor that's less than $1 million. Typically, they're $2 million. Commercial general liability policies, you want to get proof of that at the beginning of the contract.
$2 million, the policy.
And but depending on the project, yeah, that sounds
okay.
Reasonable.
Auto liability limits, $1 million.
So what, Brad? What types of insurance should the associations be thinking about? Just bodily injury, personal injury, workers' comp?
Yeah, what you want in there is you want that broad form. The occurrence policy, you want that policy for construction defects. And yeah, we pretty much focus on contracts by contractors, roofers, siding installers, painters, whatnot, because those are the primary contracts that associations enter into. That's the real meat of the association's obligations. What's important is people, pets, and parking. Right, Jonathan? People, pets, and parking are important. However, it's the buildings themselves, actually, what the association is responsible to maintain, repair, and replace. That is the important part, so we're going to really focus on those. But there are other contracts as well, and they are important for sure. Service contracts and whatnot, the big money ones are the contract with contractors. So you want to make sure that you have, they must have workers' compensation. You
what
want
about
to know
deductibles?
You want to know what the deductible or the self-insurance retention is for sure, because that's going to be what the contract has to cover before the insurance company takes over.
And you want to make sure that all your insurance, the insurance companies providing the insurance, have a best rating of no less than an A-.
Okay.
I mean, if you can get an A-rated company, that would be great, but you don't want to go with a second-rate, third-rate, fourth-rate insurance company that maybe will not be able to cover.
Excellent. When we come back for the fourth quarter, I feel like it's going to get intense. We've got Mickey from Foster City, Claire from Cameron Park.
Battle of the board members coming up.
Battle of the board members. We'll be back.
20 years of credit counseling and debt management services. More than 36,000 program members freed from credit card debt. Nearly $100 million saved in high interest and finance charges. It's Trinity's 20th anniversary, and these are just a few of the milestones we're celebrating as we begin our third decade of helping people become debt-free for keeps. Did you know that members who complete our program save on average more than $20,000 in interest?
My name is Mike. From the very first phone call, Trinity brought us relief by stopping all the late fees and collections calls, greatly reducing our interest and consolidating our bills into one easy-to-manage monthly payment. Now we're on track to save nearly $17,000 in finance charges. Happy 20th anniversary, Trinity. Thanks for helping so many save so much.
And Trinity can help you, too. Call 1-800-990-6976. That's 1-800-990-6976. 1-800-990-6976.
Hi, I'm Morgan Fussell. My company, Broadband Agreements, negotiates cable television and broadband right of entry, access, and compensation agreements for your communities. At Broadband Agreements, we offer a free review of all agreements with a signed letter of authorization. Broadband Agreements will improve your community's income and/or savings, or you don't pay us a dime. Visit us at broadbandagreements.com. That's broadbandagreements.com. Or call me, Morgan Fussell, directly at 916-939-5026. That's 916-939-5026. Broadband Agreements online at broadbandagreements.com or 916-939-5026.
The challenges presented by today's economy and rebounding housing market is forcing many homeowners association boards of directors to operate their HOAs more like a business. It's a balancing act of trying to stay solvent and still provide homeowners with quality amenities and services. One of the main challenges HOA boards are facing is attempting to recover unpaid HOA fees owed by delinquent homeowners. Collection efforts are often very time-consuming. If you want to get the HOA fees collection monkey off of your back, call ATC Assessment Collection Group. ATC is an attorney-supervised collection company, providing collection and foreclosure services to HOAs in both California and Nevada's most recognizable communities. Get back to what you actually volunteered to do as an HOA board member. Effectively oversee your community. Call ATC today at 916-641-1410. That's 916-641-1410. Online at atcacg.com. That's atcacg.com. ATC Assessment Collection Group.
News, opinion, insight. AM 1380. The Answer.
You're listening to the Saturday HOA Brunch presented by Angius&Terry, LLP. And now your hosts, Brad Epstein and Jonathan Broderick on AM 1380, The Answer.
Welcome back to the fourth quarter of the Saturday HOA Brunch. And we just want to check in with our two guests because it is time to play Battle of the Board Members. Mickey, can you hear us loud and clear from Foster City?
Loud and clear.
Claire, up in a special place to live, Cameron Park. Claire, can you hear us?
Yes, I can.
Oh,
Okay.
fantastic. Okay.
A little staticky, but I can hear you.
Oh, okay. So bear with us. This is welcome to Battle of the Board Members. We have two great board members. We're very happy. What we're going to do is we're going to have 2 rounds of 3 questions each. Then we're going to go to the lightning round. What I'm going to do is make a statement. You simply say true or false. On the 2 first rounds, you guys, you can just let us know if you want us to repeat the question. Just let us know. Say, repeat the question. Give you a little more time to think. You don't have to rush. The rushing is in the lightning round, so no problem there. So what we're going to do is it's just true, false. And the first one up at the plate is going to be Claire. Okay, Claire?
Okay.
Okay, Claire, so what I'm going to do is after each of these statements, just say true or false. And again, if you can't hear what I say correctly, cleanly, I'll go ahead and I'll repeat it. So true or false, question number 1 for Claire. And so, Mickey, you just hang on. You'll be the second round. So, Claire, question number 1. Association contracts should only be in written form if the Davis-Sterling Act requires it to be.
Repeat that last part.
Sure. Association contracts should only be in written form if the Davis-Sterling Act requires it to be in written form.
False.
You are correct. So she is correct on that one. Number 2, arbitration clauses in contracts provide for resolution of disputes out of court.
That's true.
Excellent. So you got that one right as well. That's true. Number 3, limitations of liability clauses in association contracts on behalf of the contractor are a good idea.
That's true.
And that is incorrect. So limitations of liability clauses in association contracts on behalf of the contractor are not a good idea.
I didn't hear limitations. Okay.
Okay. Oh, okay. Sorry about that. Okay.
That's all right.
Wow, we're at 2 out of 3, Claire. That's pretty good.
Well, a seasoned veteran himself in Foster City. Mickey, it's time for your first round set of questions. Are you ready, Mickey?
I am.
All right. It is prudent practice to use the association's contract template instead of the vendor's.
Would you repeat that?
It is prudent practice to use the association's contract template instead of the vendor's.
False.
Incorrect. A pitfall to avoid is a provision that requires payment in less than 30 days.
True.
Got it. Down, and for your last question of the round, attempts to shorten the statute of limitations in a contract are always favorable for the association.
False.
Got it.
Wow, it's a tie. 2 out of 3.
Okay, tie game going into round 2. Claire, you are up. 3 questions, 3 statements. Again, let me know if you want me to state it again. Number 1. Workers' compensation insurance is not that important in contracts, and it should be kept to a minimum.
False.
Correct. As part of the bidding process, the scope of work in each bid should be the same.
Would you repeat that, Brad?
As part of the bidding process, the scope of work in each bid should be the same.
False.
That is incorrect. 3. Associations should accept insurance policies from any insurance company with any rating.
That's false.
That is correct.
Oh, we're at 4 out of 6, Claire.
Okay.
You're doing good.
Mickey from Foster City, second round of questions. Are you ready, buddy?
I am.
Question number 1. Provisions requiring that the contractor indemnify the association should never be requested because contractors never agree to those.
False.
Correct. The scope of work in a contract should only be defined by the contractor.
False.
Got it. If work is to be performed in phases in a construction contract, timing for completion should be clearly defined.
True.
False. Viana, score?
We got 4 out of 6 for Mickey as well, so I think we're
still tied.
Oh, boy. Okay. Lightning round. 45 seconds on the clock.
On the clock.
Claire, are you ready?
I'm ready.
Okay, you can't ask me to repeat it, so I'm going to really try and speak clearly and just rattle them off, true, false, whatever they are. Ready?
Ready.
If directors do not understand a contract term, they may rely on experts.
True.
Some association contracts require owner approval.
False.
For construction contracts, there should be a requirement that the contractor carries insurance.
True.
It is very expensive for associations to obtain all relevant information about a contractor prior to hiring them.
True.
Construction contracts should specify the independent contractor status of the company hired.
True.
Viana?
We've got 7 out of 11 for Claire.
7 out of 11.
7 out of 11.
I'm going to go get my Slurpee at
7-Eleven.
7-Eleven, yeah, after. Mickey, lightning round, 45 seconds. Can't repeat the questions.
Couldn't hear.
I think you're going to be all right. Are you ready, Mickey, for your questions?
I am.
All right. First question, 45 seconds on the clock. True or false? It is important to have a clearly defined termination clause.
True.
Notice of termination of a contract should be in writing.
True.
A common pitfall is that associations provide owners with too much information about contracts they are entering into.
False.
Associations should never ignore contract deadlines such as payment requirements.
True.
Associations should always go with the lowest bid to keep the assessments low.
False.
I think Mickey did very well in the lightning round.
That's pretty impressive. We've got 9 out of 11 for Mickey.
Oh, well, I did hear that actually Claire didn't hear all of my statements.
What, you're sticking up for your contestant?
Yeah, I heard her. Claire, did you not hear me correctly?
No, there's a couple of things I didn't hear in the beginning.
All right,
on the limitations.
Claire, I'm going to make it up to you, okay? I'm going to give you an additional question. So, because our winner...
Mickey.
Okay, Mickey, he gets a $100 gift card,
yeah,
right?
Absolutely.
Okay, and no one could object to this, but if Claire answers this next one correctly...
Is this a double or nothing, or is this you still get second place?
No. Okay, so this is no pressure, Claire. Okay, so Claire, listen, you're going to get your $50 gift card, but if you get this one right, we're going to go ahead and we're going to bump that up. We're going to match Mickey, okay? Are you ready for this one?
I'm hoping, yes.
All right, hoping. Associations should be...
What? Just a minute. I'm sorry. There's a static in my phone for some reason.
All right. Okay.
So go ahead and just...
All right. Here we go. Associations should be aware of manufacturer's warranty language in a contract.
Didn't hear the first word again.
Associations should be aware of manufacturer's warranty language in a contract.
True.
Oh, nice job. Okay.
Everybody's a winner. Everyone's a winner on the Saturday HOA Brunch. We really want to send out our thank yous to Mickey and Foster City and Claire and Cameron Park.
Thank you, guys. We really appreciate you calling in and,
Great
and
people,
playing with us.
Board members volunteering to keep their community's curb appeal on the uppity up.
Absolutely.
Thanks for having us.
Thank
Mickey,
you, guys.
thank
Thank
you,
you,
Claire.
Claire. Thank you, Mickey.
Okay.
Okay, and want to again give our condolences
to the Management Trust.
To Management Trust, Dan Kokal's family and friends. This is untimely passing away. Our thoughts and prayers are out to them. Dan Kocal, we miss you.
Hey, Frank Jolly, thanks for everything on the sticks, my friend. We'll be back next Saturday. Viana, are you ready for next Saturday already?
I am ready.
The Saturday HOA Brunch.
AM 1380 KTKZ.
The answer.
Thank you for listening.